engaging the faith community, and we are honored to have you with us today. I'm going to go ahead and call up Ms. Carlise Greer, who's going to kick us off today. Thank you.
Good morning. I'm going to kick you off by introducing the person that will bring you welcome and greetings from the Supreme Court. It is truly an honor and a pleasure for me to introduce to you Justice Carol Hunstein. Justice Hunstein was appointed to the Supreme Court in 1992 by Governor Zell Miller. She was the second woman in history to serve as a permanent member of the court. In 1984, Justice Hunstein won election to the Superior Court of DeKalb County in a very contested election. Prior to serving on the bench, she was in private practice, and she has been a member of the bar since 1976. Justice Hunstein received her JD in 1976 from Stetson College. She was the first woman to serve as the president of the Council of Superior Court Judges, and she was the first person by virtue of that position who was not a member of the court to serve as a Chief Justice of the Supreme Court of Georgia. She has many, many honors. Just to name a few, she is a Rosalind Carter Honorary Fellow in Public Policy. She is a former chair of the Georgia Commission on Access and Fairness, which was charged with implementing recommendations of the Commission on Gender Bias and the Commission on Racial and Ethnic Bias. And I could go on, but I just want to add a personal note. I have known Justice Hunstein since I was what's considered a baby lawyer, and she has been deeply involved in ensuring that our profession and our court system is fair, accessible, and is the epitome of everything that we want in a fair, honest, accessible judiciary. I cannot say enough about how much she has done to uphold and uplift the most vulnerable and the weakest people in our community. I am so sad that she's going to be retiring in December. She is irreplaceable, but I'm thrilled to bring her up to give you a welcome, and please join me in giving a very warm welcome to someone who has not only been a leader, but a foot soldier in the fight for equal justice, Justice Carol Hunstein.
Well, that's the way to start the morning. I want to thank you all for being here. I think this is a very important initiative for justice in the state of Georgia, and hopefully it will transfer to justice all over the United States. It's important to the citizens of this state and all the citizens of the United States that they have access to their court system. Without access to their court system, they can potentially be deprived of life, liberty, happiness, their children. So this is a really wonderful and major step for all of us together to gather with the faith community and to join hands and say, let's do everything we can to make sure everyone knows what their rights are and that there's help available for them. And so thank you, each and every one of you, for attending. I'm very excited about this. I am retiring and I'm looking forward to it, but I really don't have an idea what I'm going to do after that. So, but it's a pleasure for me to join you this morning and to welcome you to this wonderful program. So thank you very much for attending.
If I could have our moderator on our next panel to start up, as well as our panelists. As the panelists are coming, if you all would look at their bios that are in your program, that would help us as they are coming. Thank you.
If y'all can just give us a second to get set up. All right. Well, good morning, everyone. Good morning, everyone. Welcome to this amazing center. If you have not had the chance to see the museum here, I highly encourage you to do it. It is an amazing place with some very incredible exhibits. My name is Leslie Spornberger Jones, and I am very honored to be here with you today. Today, May 25th, is a pretty special day for me because it was 16 years ago on this day that I got married here in my hometown in Atlanta. And if you had told me on that day that I would be spending not only this year, but last year I was in Missouri talking to judges on the municipal and circuit court judge level there about Ferguson, a national event that had changed all of our lives, I would have laughed at you and thought you were crazy. It would have never occurred to me that I would end up discussing such an important issue with such a distinguished panel. As we get started today, I want to go through and at least let our panelists tell you who they are and why Ferguson and the post-Ferguson events that have occurred are important to them. And I'm going to start with Tony on the end.
Yes, my name is Tony Loudon. I'm the director of the Faith and Justice Initiative for Department of Community Supervision. I travel all up and down the state working with reentry throughout the state, organizing faith-based organizations throughout the state. I'm also the commissioner over the statewide charter schools, one of 7 commissioners for the statewide charter schools. So I see it on both ends, the prisons, justice, and education.
Great. Thank you, Tony. We're glad to have you. And Troy.
Good morning. My name is Troy Hendrick. I'm the founding partner of Hendrick and Henry Law Firm in Decatur, Georgia. In 2005, the firm started with just me. It's grown a little bit. In between 2013 and 2015, I created my own Don Quixote's windmill, if you will, out of an old court, which is now defunct, called the DeKalb County Recorder's Court. I had been working in that court in Decatur for many years, and can't tell you how many times I saw these just very minor incremental injustices that eventually spurred me to look into a very minor little fray that I thought existed in the constitutional underpinning of that court. Through a massive amount of what grew into years of complex litigation, we eventually put them in a position where they had to stop. And so there was a constitutional amendment which allowed the DeKalb Recorder's Court to sort of move on into the annals of history. And as a result, the DeKalb County State Traffic Court, which operated under all of the auspices of the Constitution, took over, and we now feel like we have just a much more constitutionally underpinned and very safe system for people that, most people that interact with courts, obviously in municipal, are interacting with municipal courts. They're not interacting with the rest of the court system. And so this is the conduit between people that end up being jurors in a much maybe more serious case and their experience with the court system. So when they come in and sit down, they need to have a feeling that there's fairness when they walk into a court system. And if all that they're seeing is these low-level courts, then I personally think that it's extremely important that we figure out how to make sure that even on these very low-level offenses, there's a very fair process that people are going through.
Great. Thank you, Troy. Glad to have you. Rebecca.
I'm Rebecca Greist. I'm the Solicitor General in Bibb County, and I've been in that office 5 years now and was 16 years as an assistant solicitor in the same office before that, and then did a fun 2.5 years in child support enforcement to start out my legal career. So I've been at low-level court the entire time of my career. And when Macon and Bibb County consolidated a few years ago, the solicitor's office took over as the prosecutor in the municipal court as well. So Ferguson and all that we have learned from the events that happened there is very important to me, because as a prosecutor, our ethical obligation is to do justice. And justice does not always look like a conviction. A lot of times it looks like a pretrial diversion. A lot of times it looks like I can't meet my burden of proof and I'm going to dismiss this case. And so it's very important to me, number one, that we have professional prosecution in municipal courts, but also that there is the proper record keeping, the proper, probation, supervision, that type of thing, where there is an allowance for doing community service in lieu of fines, where, a lot of these injustices that we saw and quite frankly do still see in certain lower level courts, aren't occurring. So that's why this whole principle is very important to me, as it is all part of doing justice, which is the right thing.
Great. Thank you, Rebecca. Glad to have you as well. And just a little bit about my background. I've been practicing for 14 years here in Georgia. I was a felony level prosecutor in Athens, Clarke County for 6 of those. And then I served as the only judge for the Athens, Clarke County Municipal Court, where I saw lots of young people for about 6.5 years. I became interested in Ferguson issues, not because we had trouble in our court, but because I wanted to make sure that our court was a model court, and I had to learn how to do a lot of these things and manage a docket of 150 people coming in every day in a way that would be fair. Being a municipal court judge was interesting. It was a lot like stand-up comedy to me. When you put out a joke as a comedian, you know immediately if it's funny or not. If you are on the bench and you are a judge, you know immediately if you have ruled in a way that is fair or not. And so I found it very interesting in that way. So we're gonna start out because we do have a really occupationally diverse crowd today, which we're really glad to have. But we know that a lot of folks in the audience may not know a lot about how the system works. So we're gonna start out with just a brief on the system. And I want to go through the process from beginning to end. So we'll start with Rebecca, since she is the first to get to know about the charges after the defendant has been stopped or charged. So we'll start with you, Rebecca.
Okay, and there are several ways that somebody kind of enters the criminal justice system. You can be arrested, you can be given a citation, which is technically an arrest, but not taken into custody. You can be arrested, and it could be a lower level charge where most jurisdictions have an automatic bond amount set per a scale by the judges. And you'll see a lot of theft by shopliftings. A lot of the lower level crimes are in that category. But then you have crimes such as family violence crimes, personal, person-to-person crimes that will require that the defendant see the judge before a bond is set. And then, of course, you have felonies wherein you definitely have to see a judge before the bond is set, and in some cases there is no bond given. So you've got differing levels of what you see in the criminal justice system. And the cases that are on to, just a bondable amount schedule, those usually, it's pretty straightforward. Somebody is arrested and they bond out and they'll get their court date, and, they usually will show up for that court date. Like I said, on family violence cases, on person-to-person cases, probably serious theft cases, you're going to see where the magistrate has a requirement to have a hearing within 72 hours of that arrest. In a larger metropolitan area, or medium, even Bibb County being one of them, the defendant is usually in court within 24 hours, so they can go ahead and see the judge and get their bond set. And the reason for making that requirement that they see the judge for a bond to be set is that, like in family violence cases, there's certain things like don't have any contact with the victim, don't possess a firearm, don't go back to that location. There are conditions that a lot of times are placed on those bonds that are there for the safety of the victim. On felonies, a bond may be set or by the magistrate if it's a certain scheduled amount, but if it's a much more serious felony, they have to see a superior court judge in order to get a bond set. And they can be held without bond on a felony, but if they are held without bond, that case must be indicted by the district attorney's office within 90 days, or they will automatically be eligible for a bond. So those are kind of the ways that people come in. In misdemeanor cases, and again, a lot of this game as far as misdemeanor cases and cases that go to a municipal court or a probate court have a lot to do with what type of resources you have on the front end, like how many prosecutors you have, how many judges you have, because that increases the ability to have more court dates and more opportunities for people to be heard. So putting those resources in, and that's kind of a lot of times a very difficult battle for county commissioners to understand, is that really by putting in this money to the prosecutor's office, to the defense attorney's contract or public defender's office, and making sure you have enough judges has a lot to do with how swift and fair the justice is. And so, like in my jurisdiction, misdemeanor cases that have been released from jail, usually we have investigated and accused it by 6 weeks out, which is usually their arraignment date, where they come in to plead guilty or not guilty, let us know if they want to represent themselves or have an attorney. There are other jurisdictions where it just takes longer than that, because most likely they're like I was. When about 16 years as an assistant solicitor, it was me and 2 other attorneys. We had to beg for the third attorney, and we barely got a chance to read our files before we were up trying in front of a jury. So understand, resources in really does help affect better results and fairness out. But there are jurisdictions where it can take 6 months for the charges to be ready. And so, understand that. But understand, if somebody is being held in jail because they cannot make a bond, you better believe we are on top of that jail list every single day, and we will move heaven and earth to get that paperwork to go ahead and charge the case. Or if it's something like we realize, this should not have been an arrest, we're going to do a release for that defendant. So understand that for the most part, especially at the state court level, prosecutors are very conscientious and very much want to do justice and do the right thing. I think where we run into problems, like we've talked about, is in municipal courts, where in these smaller municipalities, they don't have a professional prosecutor there all the time. It's a part-time position, and they just simply don't have the resources to stay on top of it like a professional prosecutor's office would. I think I need to stop talking. Anyway, thank you.
No worries, Rebecca. And that sets us up for Troy. Once the prosecutor starts doing what they do, then you get involved generally. You may get a call from a potential client. Take us to what happens next.
Sure. Just on a basic level, a criminal defense is done through the intake of a client many times who is in custody. Rarely is that the case on municipal or low-level offenses, which I think we kind of are going to focus a little bit on in our discussion here. But in the standard sense, like you see on TV, somebody calls, they're in custody, you go, you interview them, and then you start working on the first part of the process, which is to achieve a bond to get them out of custody, if they do not already have one. And then you're going to prepare the case for representation. That doesn't always mean trial. Oftentimes, the first thing that you're going to do is gather evidence in the case, and then you're going to see what the evidence is that the state prosecutor has. Because as a defense attorney, my job is very different and has a less complicated aspect to it than Rebecca's. Rebecca has, in addition of the duty to prosecute prosecute a case on behalf of the state and achieve convictions, she also has a duty to seek justice, and those often come into conflict. And that's a very complicated position that she is in, and she has a lot of great thoughts, and she has discussed some of that duty, and I'm sure she'll go into it more. My duty is much more simple from that aspect. I don't have any kind of duty to anybody but my client. And that allows me to avoid some of the ethical conflicts that Rebecca has to face every day when she looks at cases and she thinks, well, this is on paper, I can get a conviction here, but it's not right. There's an ethical and moral obligation to see that I do something different in this case. A great example, and Rebecca and I have talked about this a lot, is the situation of driving on a suspended license, because while there are plenty of people out there who are just derelict in their duty to go get the right paperwork in order or to take care of other issues that may be the cause of suspending their driver's license, there are also people out there who just don't have the resources, the education, or the ability to facilitate their own interaction with a low-level court system to get their license back. And so what that means is they drive without a license because they have to go to work and they have to pay child support or they have to provide for the people that they care for. And then they get another driving on a suspended license because they have no choice. And that is the kind of situation that we see. That's probably, I think, the best example. Rebecca would probably agree with me, where you just get this spiral. And it doesn't have anything to do with justice. We're not actually serving the community by continuing to pile on the suspension of this person's driver's license. And one thing to keep in mind, under Georgia law, in this particular anecdotal example, the suspension of a driver's license it compounds itself. So the first time is a period of time of a year, I think, and then the second time it becomes a 5-year suspension, and then I think by the third time you've got what's known as a habitual violator revocation, and then now you're talking about the fourth time, you're talking about a felony charge for somebody who's just literally driving, and that's it. And so you sort of have this disconnect between what's right and what can happen if we just look at the black letter of the law. And Rebecca runs up against that, and she'll talk more about that, I know. My job is simply to be sure that Rebecca, for instance, has all of the evidence that means that she can prove the case beyond a reasonable doubt. I know a lot of us in the room are not lawyers, and I want to just take a moment to say that I think that's incredibly important. Walking around this facility this morning, just stepping into some of the exhibits upstairs, I have a physical reaction. I literally have physical feelings and chills in my neck and back from looking at the history that's represented here. And I urge all of you to take the time while you're here to make sure to see the center. But my job is to make sure that I just see that the state can apply their burden of proof to the case. So I don't have any kind of duty to see that necessarily that justice is done in terms of what is right in the universe. Justice in our criminal system is done only when the state can meet their burden of proof beyond a reasonable doubt. And if I can see disrespectful to disregarding what the actual matter is and what I may know, what the facts of the case are, it doesn't make any difference. The important thing to me is to see that the state can prove the case beyond a reasonable doubt. And I personally believe that we have the greatest justice system in the United States of America that has ever been devised by any civilization that has ever existed on the face of the earth. And that does not mean that it's perfect. It means that there are all sorts of problems with it. But when you look at it in a long arc, in a huge arc, what we typically see is justice. We typically see that the right thing is done. And the only way that works is if every single person in the system does their job right. And that means that if Rebecca does her job right, it means that the defense attorney does his job properly, which is to hold the state to their burden of proof. It means that the judge does their job properly. It means that the court reporter does their job properly. It means that the bailiff does their job. If every single person in the system does their job properly, then we should see the right outcome. And that's an amazing system when you think about all of the history of humankind and civilization for the justice systems that we've come up with. It's an amazing thing that we have devised a system that can do that. But it only works where we all apply the proper standards, where we all do our job properly. And we see a fraying in that system when we look at low-level courts. And that's what Ferguson taught us. That's what everything that has come out of Ferguson has allowed us to re-examine. And I think it's incredibly important that we look and see those failures and address them. They tend to so often get overlooked because of the low level of the severity of the crime. I mean, for one thing, most lawyers don't take these kind of low-level cases. They don't make enough money. For another thing, people who are looking at a $250 fine, they're not going to also pay $400 or $500 or $600, which is going to be the lowest that you'll ever see for an attorney to go handle that case for them in court. So you have this wild, wild west going on that's right in the face of what is an otherwise very well thought out criminal justice system. And so, that's where one of my interests lies. But in terms of representing my client, it's my duty is to the client, and that is pretty much the sole duty that I have.
Okay. And we do that through vehicles called motions, where we file a motion with the court, ask the court to look at something, some issue, and then the court will actually rule on those. They'll hold hearings. Sometimes those will require evidence, maybe witnesses that come in and testify, maybe actual documentary or physical evidence that's presented for that to be done. And after that round of motions, then we get to a position where the person decides who's been charged whether they want to have a trial or not. If the trial occurs, then the judge will sit on the trial, if it's a bench trial. If not, a jury will sit and hear the case and make the determination whether the person committed the offense or not. And then afterwards, the judge will sentence if they are found in violation. If not, then the person is acquitted and they go free. Which takes us to Tony, who is involved with sort of the post-conviction process and what happens at sentencing and how we help people who have been sentenced to rehabilitate themselves so that they can remain in society and so that they are not affected. So Tony, tell us about what you do and how your work is so important in this process.
First of all, I'm glad to be here today. I'm going to throw some numbers out at you. I hope you write these down and meditate on these numbers. 53,000 inside our prisons. 31,000 men and women in our jails at any given day. 15,000 juveniles either in our YDCs or have some form of supervising officer that's watching them, or they may have a monitor. 190,000 people on supervision in our state where they have what we now call a community supervision officer. Those are just felons, not to include those that went through our lower courts for misdemeanors. When they get sentenced and they go to our prison, they end up somewhere down in Forsyth, where they end up getting an assessment done on them, a diagnostic center there in Forsyth. And then they end up somewhere on those white buses that you see up and down our freeways. And they end up getting moved to some of our prisons in our states. Inside those prisons, once they get there, they meet with what we call a reentry counselor, where they get placed in isolation until we figure out whether or not the person is a threat to themselves or a threat to the population, or someone will prey on them. And I don't mean P-R-A-Y, I mean P-R-E-Y. Then we separate them based on whether or not they're mentally ill. We have veteran dorms in our prisons. Now that's something new. Think about that. Veteran dorms in our prison. A dorm usually have anywhere between 60, 70 men in a dorm, or women in a dorm. We've got so many veterans in our prisons now that we have to have veteran dorms. We segregate folks based on whether or not they want to go into a faith and character dorm. And then we start working on trying to get them ready to go home. In Georgia, we do a great job of removing them, but we do a terrible job of repairing them and correcting them so they can come back home and be whole. So under this whole initiative, what we call Georgia PRI in Georgia, Governor Nathan Deal put this plan into action where we work with the faith community, we work with those nonprofits to help identify certain needs. We do the assessment as soon as they get there, and then we look at filling those gaps as it pertains to housing, as it pertains to education, jobs, reuniting them back with their families, trying to look at ways of changing their criminal thinking. Also, we look at ways of trying to find how we look at ways of changing the system itself. Because it's one thing to try to change the person who's inside our prison, who we now call our returning citizens, but it's another thing to change the culture. Because there are some that still believe that we should just throw them away and lock the key up, and they're convicted and they're defendants and they're felons, and they don't embrace this thing called returning citizens. And so we have staff out in our fields that build capacity around housing, jobs, and ancillary services that can help this person once they get out of prison. We even have family days inside the prison to reunite them with their families. We put charter schools inside prisons. We have 3 now, helping those younger ones get their high school diplomas. All 53,000 now have tablets inside the prison where we can put their education or reentry packages on side what we call a Go device tablet. We're doing heating and air and welding. We have a prison now that's in Leesburg State what we call the evidence-based prison, where programming is going on all day. And just recently, we come online here in Atlanta, in Fulton County, Metro Prison. Now it's called the Metro Reentry Prison. Men there who have 2 or 3 years left on their sentence will come there and get programming and jobs, heating and air and welding and skill sets all day long, just so that we can get them ready to go back to 6 of the counties here in Atlanta. Why? Because those numbers that I mentioned to you earlier, we can't keep up with the numbers. Although we now have diversion courts, veteran courts, mental health courts, drug courts, fatherhood courts, we still can't keep up with the numbers because there's a pipeline to keep feeding. And all our systems throughout the state don't look the same. Rural sentencings and locking folks up don't look the same as what we get in Metro. And so all those things are taking place, we have to deal with those effects. So I see young kids who are 18 doing 30 years to life for something that they would have done in Atlanta wouldn't have been the same because that rural court put their foot on their necks. There's so much I would love to say, but I want to move along. I saw the green signs bumping up, but I want to tell you we can't keep up with the numbers. And we have other states coming into Georgia, visiting our office and looking at all the things that we're doing throughout the state. And to our faith community that's in here, we have seminaries inside our prisons now. Phillips Prison, we have New Orleans Baptist Seminary, and we're getting ready to do the same thing for a woman's prison. We have Emory University doing a seminary at Lee Arrendale Prison. Why? Because we're creating men and women with 4-year degrees that can preach inside the prison. So what do we need the faith community to do? What makes my job special? My job is to recruit the faith community to come inside the community, inside the prisons, to reclaim your sinners. Why? We have a system that houses people for sin. That house people for sin. The faith community, regardless of your denomination or what you believe, you are doctors of sin. We need you to build and repair those relationships and bring them back to their communities and then be the governor of your community. We wouldn't have Ferguson's if the faith community stand into this rightful place of being the governor of your community. You are the ones that can legislate in your community. You are the ones that can rally the folks in your communities. Forget about the legislature helping you. Forget about them making you promises because they never keep promises. You are the legislature. You are the governor. You are the man or woman of God of your community. You're the covering of your community, and they're your people. And getting access to justice means getting access to knowledge and libraries and lawyers and being able to give our people that knowledge. 58 years after King, and we're sitting in the civil rights building and we're still talking about justice. But the people inside our prisons, they believe just them. Thank you.
Thank you, Tony. Good point. And we have Francis Johnson just joining us now. Glad to have you, Francis. If you would take a moment and just introduce yourself, or if you want to get a moment and a breather, we'll come back to you. How about that? However you want to do it.
There's no moment to breathe, not in this climate that we are in, especially when we have folks who are declaring with their last breath they can't breathe. So grateful to be here and be a part of this great discussion. I am a lawyer and pastor and try to use both of those to help people help themselves, practice constitutional tort law as well as civil and criminal law in the state courts, federal courts here in Georgia. And I am the recent declared nominee for the Democratic Party for the 12th Congressional District, help set some better federal policy. Looking forward to the conversation, what remains of it. Thank you for having me this morning.
Awesome. Glad to have you here. Tony was talking about sort of the felony process, but even at the local level in the misdemeanor process, there's a very similar way that probation departments and sentencing is designed to help rehabilitate folks and to give them opportunities even on low-level offenses. So his overview of the felony system works to misdemeanors as well. What I want to do now is just really briefly ask each of you what you think is the most difficult thing for people to understand about the criminal justice system, just very briefly. And while they're doing that, we have given y'all index cards. If you do have questions, please write them down, and we'll be collecting those at the end, and we're going to try to get to some of those questions at the end of the panel. And I'll start with you, Francis, if you don't mind. What do you think is the most difficult thing for people to understand about the criminal justice system?
That it is a system, and there are multiple actors across that system that either make it work or that keep it from functioning. And within those actors is a great deal of discretion, and that begins with frontline officer and how they respond to a scene. It continues through discretion in terms of an accusation or an indictment by the prosecutor. Continues through the discretion of the lawyer, public defender, or private attorney in terms of how they proceed with the case, what actions they take on their client's behalf. It continues through the judge. It continues, hopefully, truth comes out. It continues through probation. It continues through sentencing. It continues across the whole system. But it is a system, and systems are flawed because human beings are flawed. And so what we have to really work at is making sure that across the system, through all of the various players, that we have as diverse of a set of human beings to bring a diverse set of backgrounds and experiences to influence that discretion towards the best interest of all of us, that we have beyond diversity, that we have a sense of justice. What are we trying to ultimately accomplish through this system? We never lose sight of that because systems can have mission creep, and of course that's what we're dealing with, and that's why we are in the process of reforming systems to get them back to task. And then I think the final thing that I would urge about systems is that all systems can be improved with more knowledge, understanding, and investigation, and so no system should be so sacrosanct that we don't always critically examine it. I would urge that's one of the things that people fail to appreciate. It's a system.
All right, Rebecca, what do you think is the most difficult thing for people to understand?
Just, from my perspective,
Yes,
that
from your
honestly,
perspective.
the professional prosecutor is truly trying to seek justice, and that understand that sometimes justice is a conviction, because we have to take care of victims as well as making sure we're doing justice by the defense. And there's always that tension, but please understand that 99% of the time the prosecutor is doing their absolutely dead level best to do justice.
Okay, Troy.
I believe that the most difficult thing for people to understand is that people of power and privilege are treated differently by our justice system from the moment that they have the very first interaction with an officer all the way through the entire prosecution of their case, all the way through the incarceration that they may befall them. It is very difficult to believe for people of privilege and power that people that do not have privilege and power do not experience the system in the same way. It is much different for them.
Yeah. Tony.
I would agree with all the panelists here, but one thing I would like to say is that if you use your imagination to think about those communities that don't have a grocery store, you think about those same communities that when the digital divide, we talked about an on-ramp to the information highway. Well, we still have communities that don't have on-ramps to the information highway. When you talk about infrastructure throughout our state and across the country, those same communities don't have infrastructure or roads that bring business to those communities. Well, I want to say to you, that's the same way with justice in those communities. And they don't understand why they don't get that same access that the privileged gets. They don't understand why they always have to get a public defender, and then the first thing out of that public defender's mouth is, let you take a plea, instead of going to court and trying to prove your innocence. And then the second part on the back end of that, and I believe the system don't understand that every person deserves a second chance, and sometimes a third chance, and that this system is not set up for everybody.
Thank you. So we're 4 years almost removed from the death of Michael Brown in Ferguson, and there had been a real hope when the system was exposed in that city, that things would change drastically. I want to start out with the negative and move to the positive. What in the last 4 years had you hoped would change after Ferguson that has not? And I'd like to start with Troy on this one, and then we'll move around the panel again.
What we've seen in Georgia, we have seen some improvements, and I believe that those improvements are a result of political and cultural shifts as well as litigation happening at the same time. I sometimes wonder if one had happened without the other, would it have been enough to bring any change? And as so often happens in these types of situations, other political events take over the news headlines. We begin to move on from these things that occurred, these great injustices. And my thinking of what is the biggest changes that we have seen are in Georgia. The most tangible thing that I can say is there has been a change in the laws regarding failures to appear, which goes back to this cycle of driving situations that we've talked about. There's a new law under 17611, which I think is part of the bail reform bill, that requires that the local clerk of court notify the individual that missed their court date that they missed their court date. They have to send it by mail to the address on the citation, and then they have a 30-day period to go remedy that situation before the clerk of court sends that into the Department of Driver Services, which would cause another 21 or 22-day period, one of those two, to begin counting before that individual's license is suspended. So we've sort of set up a bit of a safety net to try to staunch that particular problem at its source. And I think that I know that the legislation that came out of that bill, as well as the good things that have happened in terms of probation reform, are a result of cultural shifts that made that possible. That was a big part of what Ferguson brought to us.
What do you wish had changed that didn't?
You know, I've talked with Rebecca about this, and we discussed this as a group, but we have a real problem with these low-level offenses being classified in Georgia as a criminal offense. I mean, technically, a stop sign violation can land you in prison for 12 months. That's crazy. And there are line drawing problems because obviously if somebody's going 175 miles an hour down I-85 in a Maserati, they probably need to be going into custody. The officer needs to arrest them. But what we know is that this cycle of unfairness that happens to impoverished and unprivileged peoples is something that occurs literally after things like stop signs. And if we reclassified these offenses as administrative or civil in nature so that you can't go to prison, you can't lose your license, you can't show up in a municipal court that's processing thousands of these violations a week in a metropolitan area and doesn't have time for you to prove your innocence, which is really what has to happen. I mean, the entire justice system is flipped on its head when the evidence against somebody is some officer saying they failed to come to a complete stop. And you get up there and say, wait a minute, I did come to a complete stop. Now, if that were a murder trial, that person's gonna be exonerated every day of the week. That's not proof beyond a reasonable doubt. But somehow, in our system, that creates a conviction for that person. And that's not right. There's something wrong with our system when that's possible. And so this has been bandied about throughout our legislature and our court system for some time, and it's being talked about among academic intellectuals, and it got talked about again with Ferguson. We've got to figure out how to make a large swath of our misdemeanor, low-level crimes, we've got to classify them as something other than criminal, punishable by 12 months in prison. And that hasn't happened, and I would like to see real discussion continue about that and legislation come out of that.
And to Tony's point on that, you folks are the ones who can really drive that by letting people know that that concerns you if it does. Francis, what do you wish had changed that hasn't? And what has changed that you think is good?
Well, one of the things that I'd hope at change that we would take a real look at the system of policing itself. I mean, let's not fool ourselves. The whole expansion of the criminal justice system comes about with the adoption of the 13th, 14th, and 15th Amendments to the Constitution, that the slave patrols were simply rebranded as police, and low-level offenses like not having a job after the Civil War, not having a home, these sorts of low-level offenses for just being a person who was an ex-slave that was criminal, is a part of the history of policing. And to ignore that is to continue to fester the false narrative and the distrust that the people who have a knowledge of this feel for police. And there was no righteous reconciliation of that history. And before there can be any reconciliation, there must be the telling of that truth. Truth must precede reconciliation. And I thought we would engage in some truth-telling in this country, but we didn't. We simply took sides. Either you were going to back the blue or you're going to stand with the protesters. And I found myself during the unfolding early chapters after Ferguson as the head of the NAACP, a group that is formed to make real the promises of our democracy, the Constitution, and the rights thereof, but who had an obligation to stand with protesters who had a righteous claim. And I don't think it was the dichotomy that was laid before us. The police were put in a difficult position to enforce policies that were bad policies, that were set by policymakers that were not diverse, didn't represent the whole community. And there they are with a badge and a gun enforcing policies, terrible policies. Some of the lowest paid public service that we have, lowest trained. You have to have more training to perm someone's hair as a cosmetologist than you have to receive in the state of Georgia for de-escalating situations, for example, with those who suffer from mental illness. Not enough training in simulated situations involving deadly force. Not enough training involving people of different cultural backgrounds. And this is just a part that I wish that we had the courage, and our Attorney General called it for what it was. He said that we were cowards, and instead of facing our cowardice, we took issue with his statement. But it was a true one. We simply lacked the courage to look deeply within this wound at the underlying issues that were there. So that's the bad part. The good part is that there's a generation that is woke, as it is said, and they are determined, like every generation, to make this a more perfect union. And so they're out in the street, they are running for office, they are going to law school, they are using every sphere of influence that they have to push this country in a different direction. And so I'm hopeful in this moment. And those of us in this room would do well to push them forward, to give them every bit of encouragement we can. And that is why I made the determination as the NAACP that we would renew our commitment, and every single demonstrator who was arrested, more than 1,000 demonstrators across Georgia in the 3.5-year period that I was president, had a lawyer. And those cases were largely dismissed because we worked with prosecutors who understood that this was a righteous moment. Every one of those protesters knew that they had the backing of older, more experienced activists who was not going to leave their side. And I think if you have any sphere of influence as a pastor, as a lawyer, anywhere that you have power, you would do well to lend it to these young people.
Great, thank you. Tony, I'm going to move to you. What do you wish had changed that hasn't, and what do you feel like has changed for the better?
Well, one of the things I wish have changed out of Ferguson, one thing we recognize is that you had a community that was majority African American, but those that on the local level that ran the system were all white. The police was basically predominantly all white. If you look at what's taking place in these communities that I oversee up and down the state, when I go to those communities, the school board, the city council, the city hall, the commissioners, the police chief, and majority of these rural communities look like people that actually don't live in those communities. And so when we talk about what have changed, do we have more diversity at the table making decisions of folks that are governing those communities? Not happen. And here's the proof to the pudding of the numbers. Of those 53,000 I talked about, 90% in some of our prisons are majority black. Of the 31,000 I talked about in our jails, 80 to 70% of them are majority black. The 15,000 juveniles that are in our YDCs, majority of them are black. 190,000 on probation, majority of them are black. Well, the African American community is only 30% of Georgia. It don't add up. And so the one thing I do like is that there's been a push for officers and correctional officers and community supervision officers to wear cameras. But that is still suspect in some cases because they have the ability to turn them off and turn them on. And so just like you saw the NBA player get tased just the other day and he gets an apology from the mayor, but if it was the other way around with somebody in that community, if you looked at all those officers in that community, when the NBA owner stand up and says, it's the most racially divided community he's ever seen. It's the owner of a franchise in that community. Not much have changed. We got a long way to go. And we have leadership in America rolling back here in 2018 where we have a culture of 1968. We got a problem. I drive up and down this state a lot of times in a government car, going to prisons all over this state and working with churches. I'm afraid as I drive up and down this state. So I know what it's like, a person that's living in those communities. They have to be afraid. I'm afraid when I get pulled over. And so, has it changed much? We got a long way to go. That's why I hope that the faith community, I talked about this several times to some of you pastors, and that the fear is two things. We can either face it and run away from it. Face it and rise over it, or we can face it and run from it. Forget it. Now, I tell you, the latter, we can't do because these young people say they're not going to march with you. Andrew Young is fighting for his life in the hospital. Civil rights leader. All our civil rights leaders are making their way home. These young people are our new civil rights leaders. And in churches, you're going to have to sometime take these Bible classes, these Bible studies, and start teaching about how to live when you get pulled over. How to live and teach these parents how to fight when their kids get kicked out and expelled in school and then end up in our YDCs. We can't do things the way we used to anymore. You have to teach a community how to live, and you have to be the governor of that community. Give them real life applications on how to make it. And when your people of your congregation, your community end up at the system, the day of, not the day of sentencing, the day of when they're charged, you're standing there in the courtroom saying, give them to me. If they don't give them to you, then you need to start building a room up and building a case why they should be free. And then get people elected that sit on those benches because they're going to be at your church on November anyway, or May.
Yeah, and I can echo that with clients. It's always amazing to me to go through, say, a major trial, and at the end of it, be at sentencing, and have spent months trying to figure out what can we say about this person so that when the judge does ultimately sentence, they will see my client as the human being, the loving person that they are, and that this one thing that they chose to do that was a poor choice does not define them. And it's always sad to me to see how many people don't come to the table for those people. And so then I'm standing there being that voice, which is awesome. But if the whole community was there to say what they knew about my clients, because the whole community is there, they all know them, then that would be so much more powerful for our system. Rebecca, what do you wish had changed that hasn't? And what has that you like?
Yeah, I think that probably what I was really hoping for and continue to hope for is that we have some sort of more standardized municipal court system where there is a professional prosecutor in place. And I don't know if that means that, like in the smaller jurisdictions, they combine counties just like they would with the district attorney and have, you know, a circuit-wide solicitor general or a circuit-wide public defender or circuit-wide contract, that type of thing. I think we could see much better results if that's what we had, you know, the players in those communities. So that's probably what I wish had happened and has not happened yet. What has happened and what does please me a lot is so many of the criminal justice reforms that have come about in the last few years, that being that it used to be that you could not get rid of your probation fines and your state fees and that type of thing by doing community service work. Well, that has changed. Now every single bit of your fines, fees can be taken, probation supervision fees can be taken care of with community service. So it takes out that element of you're basically in debtor's prison, because that's just wrong. I mean, that's fundamentally wrong. So glad to see that. Glad to see a movement towards, also in this criminal justice reform, it used to be that if you had a possession of marijuana charge, even, you know, less than an ounce, you lost your driver's license. And it didn't matter if the marijuana had anything to do with the crime, you know, with, if you were in a car or you're driving or anything like that, you lost your driver's license. So anyway, that has gone away, and they automatically reinstated all of those licenses that had been taken for that reason. And that's a huge positive. So not there yet, but we're getting there a little bit.
Yeah, awesome.
At the same time,
Go ahead, Francis.
look, the city of LaGrange is still converting leftover fines and fees into civil judgments and attaching them to people's electricity and water bills. And so if you want to look at a real injustice there, look at it. We looked at the problem from a legal standpoint and tried to sue under the Fair Housing Act. Because obviously, if you can't have electricity or water, you can't occupy a residence. And so we'll continue to look at how we might get at this problem. But for those of you who have some influence and discretion, you need to look at the city of LaGrange and their standardized process of converting fines into a civil garnishment or a judgment and attaching it to your water bill since they run their own utilities. It's a problem. And again, this is the system. As you knock down barriers, as a solicitor spoke to us about those barriers that have been knocked down, new barriers are erected. And so we have to continue, because freedom is a constant struggle.
It is. And I can, for Athens, Clarke County, and a lot of other local cities, believe it or not, the failure to have electricity can be a criminal violation under that local ordinance. When those cases came before me as a judge, I always got rid of them.
Yes.
Because I was like, how can you find this person guilty for not having water when they can't pay? It makes no sense to me. So that's something to be looking out for, and goes to some of the discussion we've had. What is criminal? Why is it criminal?
Yes.
Why? So some of the reforms have included bail reform, and actually this year the ACLU in California has called 2018 the year of bail reform. Tony mentioned the statistics on people that are in prison right now, but did you know that 2/3 of people every single day in the United States who are incarcerated are actually incarcerated pre-trial? What is the root of this problem, and how do we fix it? And I'll let whoever wants to jump in on that one start.
Well, in my case, I think it's bail reform without a doubt. I mean, folks can't afford to be released. In some cases, the system is designed to put that on you where they end up getting you inside the system and you're waiting and waiting and waiting, and there's a ripple effect. This person now loses their job. The children of that particular parent now end up losing their sole provider in the household. And then it becomes a ripple effect, because this child, whether it's a teenager, may end up doing something where they're desperate so that they can feed themselves. And guess what? Now you have mom, dad, son still both looking for bail. And so I think this bottom line is the fact that we are putting cases on people who can't afford to get out or get a lawyer. And that goes back to what I said again. A community that do not have an on-ramp to justice, access to a lawyer, access to people who can help you. There was a summit at Morehouse 2 weeks ago where a young man developed an app so that if you get arrested, that app right away called up on a lawyer while you if you get pulled over, this app clicks on your phone sits there on the dashboard, and your lawyer is talking to you and the police at the same time.
Oh, that's awesome.
And he's trying to get that app off the ground so that he has a lawyer on call all the time. That same app has a part where you can, your friends, just like you have friends on Facebook, you get arrested, it sends messages out to your friends that, hey, I need X amount of dollars for my bail, I've been arrested. And all of a sudden, a GoFundMe page is started for your bail. We have to think outside the box for folks who need access to justice. And I'll close with this. It breaks my heart to see young men end up going to prison, waiting to go to trial. When they go to trial, no one's there. Faith community's there, the parents not there. And then they Google him or look on Facebook and see that he got a picture with some friends, all dressed in black or blue or red. And you get an extra 5 years just because he got friends that dress the same way. And you don't really know whether or not he's actually in a gang. But just because they all dress the same, you end up with an extra 5 years. I just seen a young man with 18 years old for armed robbery get 25 years. And he's in one of my level 5 prisons. Break my heart. Because that young man was in my nonprofit program, At-Risk Kid. And he spent all of his trial time in jail.
Right.
So, that's just me.
Rebecca.
I will say that at the legislature, I serve as chair of the legislative committee for the Georgia Association of Solicitors General, and a lot of the Criminal Justice Reform Act dealt with bail reform, misdemeanor bail reform this year. And so the positive that came out of that is that if there is an offense that would be you could arrest by citation for any probate court, municipal court, or magistrate court, you can also do the arrest by citation at the state court level. And what that does is, now in a shoplifting type of situation, it is required that you get fingerprints because I just, in my experience over the years, believe it or not, some people use somebody else's name when they get caught. And so, you may have some poor soul who has no idea that these charges are out there, and then they get picked up on a bench warrant because their buddy who gave their name didn't appear for court. So, I mean, there are things that are in, we're trying to make sure that we're balancing we need to know we have the right person, but also balancing hey, where do we need to come off of bail? We don't need to be holding, especially on misdemeanor cases, someone in jail awaiting trial or awaiting court in that situation on a misdemeanor. But with misdemeanors especially, you have over 2,000 misdemeanors in the state of Georgia. Everything from the stop sign violation to a very serious second-degree vehicular homicide or battery family violence, it's all considered a misdemeanor. And what we have not done, like we were talking about in Georgia, is classified those misdemeanor as to levels, because I think everybody would agree that's a big difference in, your victim's needs, the interest of public safety, that type of thing, between a stop sign violation and battery family violence. So what we are committed to doing, and there is a Council of Judges committee that is going to be working, and the Solicitors General have a committee put together as well to sit down and thoughtfully look at every single one of those misdemeanors and classify them as to the severity, so that when we come back with misdemeanor bail reform, okay, well, we can now agree that all Class C misdemeanors can be just arrest on citation. Whereas, and another thing that came up kind of at the last minute in this legislative session, and we were really out of time to thoughtfully make it happen, is whether or not you can have criminal convictions restricted. And so understand that there really is a lot of work going on behind the scenes to try to get to the point where we can get to some serious, thoughtful, and hopefully very successful legislation where we know that we're doing arrest by citation and not holding people in jail on minor level offenses, especially if they don't have any kind of history, just because they simply can't afford to post a bond. So, I mean, that's kind of what's going on there.
Okay.
And I'm hoping that that's where we can go forward.
Great, thank you. One of the things that's happened in the last few months, to move to sort of a related topic, because Rebecca was talking about sort of classification of misdemeanors and that sort of thing, is that the district attorney in Philadelphia, Larry Krasner, came in with a lot of ideas. He was a civil rights attorney before he went into that office, and he issued a memo in February to his assistant's DA. And he told them, for instance, things like this: we will no longer charge marijuana cases. We will no longer charge prostitution cases against the person who is the prostitute in certain circumstances. We gave a copy of the memo to the panel prior to today's talk, and I want to know if y'all have any thoughts about some of the ideas that he had and if they should be brought into Georgia. And I'll let whoever wants to jump in on that.
That's what that is. It's called prosecutorial discretion. And prosecutorial discretion is an incredibly powerful tool that has got to be used in this country. And it is too often that prosecutors aren't even educated to the fact that they can use their own discretion. And we see this very often in municipal and low-level courts, where I can't tell you how many times I've walked up to, oftentimes these are very young prosecutors, and I've walked up to them and said, listen, here's why you need to do this. This is why I think you need to do it. Well, I would love to do that, but the judge won't let me. And that's a fundamental misunderstanding of their role in that court. And it happens all the time, especially in some of these rural courts where you've got somebody that needs to step up and take charge of their duty to exercise their discretion to see different outcomes in cases where unfairness is the result. And there's a fascinating law review article by Babe Howell, who's a law professor at the City University of New York, and it was published in the Georgetown Law Review. And she looked at the ethical duty of prosecutorial discretion, and and then she went through a very fascinating analysis, and the result of her analysis was that pretty much all low-level crimes, because of things like Ferguson and because of things like fairness not occurring for the underprivileged members of society in these low-level situations, that the actual analysis leads the ethical prosecutor to literally just dismiss every one of these charges right out of the gates. And it's a very interesting article. I brought this up before. I don't necessarily know that if you apply it, it's a radical change, but that's the type of thinking. It shows that you can do this. It is legally logical to look at a situation and just say, well, I got to dismiss this. And never allow it to get in front of a judge or a jury, and never allow these situations of unfairness to manifest themselves.
Francis.
Good.
No.
Oh, sorry.
Well, I'll say this. Go read a book called Racism Without Racist. Again, I find myself on these panels, and there's a sense of sort of innocence to this. No, there's discretion that is decided every day, and it's decided against poor people. It's decided against people of color. It's decided against people who are not native English speakers. It is decided against people who have a number of disadvantages in the system, and it is decided for people who have advantage. And until we begin to call it what it is, this system will continue to produce the same results. And so what you have in Philadelphia is a game changer who comes into the system. Because if you just replace actors, and we need diversity on the bench, so we'll choose a person who's African American, but they don't have a game changer mindset, you're gonna get the same outcomes. And so, amen to the Philadelphia prosecutor for being a game changer. Now, the question I have to the ministers in the room, how are you gonna change your game? Because you decide how you'll spend your time each week too. How much time you'll spend in your study preparing your sermon versus how much time you'll spend in the community actually with your hands on people. You decided today to come here as opposed to just take lunch with your other clergy members at home or to take another day of golf, self-care, excuse me. All of that is discretion in how you spend your time. But to sit here and act like, oh, we've got this system can be changed, but it won't be changed unless we become intentional about it. And I refuse to let people hide behind their so-called ignorance about how this system is operating exactly how it was intended to operate. It is grinding through the people and the communities it was intended to grind through. The rise of the police force in this country was predicated on controlling the savage masses. The leading police authority spread of police across this country. And until we honestly look at ourselves, and we are just in an illusion. Of course we need bail reform. The reason why we don't give people bail is because we want to punish them before they're convicted. That's why judges don't set bail. Just tell the truth about it. We see this person as a criminal. We saw them before they even stepped foot in the courthouse as a criminal, which is why we over-police their communities. The reason why we over-police their communities is because we saw them as not deserving functional communities in the first place, which is why we haven't invested in those communities and put parks and playgrounds and functional schools and jobs and things in those communities, because we saw them from the very beginning as not citizens, which is why for 231 years we've been trying to make real the promises of that first statement, we the people. You want to talk about access to fairness, get some more game changers like that Philadelphia prosecutor who see we and we the people, the first words in the preamble to the Constitution, as meaning as many of us as possible. And until we do that, the rest of this is just, fiddling around the edges, window dressing, making ourselves feel good for how we spend our time. The system needs fundamental reform, top to bottom, about an attitude. If I can just give this one example, and I won't give any further comment. Michael Boggs, the Criminal Justice Reform Council, did a great job of putting forth a set of policy revisions, for example, to sentencing. And one of them was they reduced overall sentencing for most crimes, reduced the amount of time in a probation detention center from 720 days to 180 days max, established more residential substance abuse treatment facilities, all good things. Prosecutors in my area of South Georgia, where there's never been an African-American hired in an associate part-time magistrate, no African-Americans ever in the entire history of the Ogeechee Judicial Circuit in the prosecutor's office, no African-American solicitor, period, in that whole circuit, ever. They're now bootstrapping PDC to RSAT, which was supposed to be remedies to make, and this is every one of them say this, so we can make sure they at least stay in jail for a year and a half. So the reforms, they're trying to work around those reforms to give people more time, contrary to the statutory intent. And I laid the statutory intent in front of them. I laid the minutes of the Criminal Justice Reform Commission. I laid the statements of the governor. I said, you're going against the statutory intent. These people are criminals. They don't deserve to be free. That's the practicality of even the reforms we're passing, is that folks who don't have a change of mind work around that to get to the same outcomes.
Okay. Thank you, Francis. One of the last things I want to leave us with is that Ferguson was a court that was not observed by the community. People went into that court as defendants, but community members who just wanted to sit in that court were not allowed to. Every court in this nation is open to the public every single day. Doesn't matter what level of court it is. If they are running court, the community has the right to come and sit and just watch and see what's going on. You've heard from this panel what's going on that's good, what's going on that's not good, that we still need to see changed. You are instrumental in your communities. We encourage you to get into those courts, to see them run and ask the right questions. Yeah. And that ends the questions from the panel and to the panel, but we're going to go to some of the questions that y'all have. And I want to start with this one. Are we moving from a prison industrial complex to a reentry industrial complex? A system that appears on its face to be concerned with redemption, but still controls poor people of color and keeps them in poverty. What an amazing question. What say you, my good panel?
Well, I guess I'll take part of that since my office is in charge of reentry. First, I want to say this. We praise Philadelphia, and Philadelphia comes to Georgia because Georgia is #1 in the nation in prison reform and reentry. And we've done it in the last 5 years. Are we moving to a industrial complex of reentry prison? I would like to say deep down inside, the people that's doing the good work from my shop, GDC, some of the other areas of people that I know personally, I would say we're not moving that way. We really have people that have passion that want to do that. But I want to tell you, passion changes with politics. In other words, when a new administration come in, if they decide they want to go the same different way with a different culture, then the people with passion is on the ground doing the work, that will change. But this model that we have with the Fulton County, the Metro Reentry Prison, there's no place like it in the country. The evidence-based prison that we have in Leesburg State, there's no place like it in the country. We're getting ready to put that same type of culture in Hancock Prison, and there'll still be no place like it in the country. But what will happen come November, depending on who these pastors in this room let come to their office, their churches, and get them to solicit their votes on Sunday and wave their hand and stand next to your pastor, and we don't ask them the question how they feel about criminal justice reform and reentry, and they get inside the office and talk inside the Gold Dome and talk about rounding people up with a bus. We could go back to some type of industry that's locking people up. I would hope and pray. Yes. I would hope and pray that wouldn't happen. And two, I'm so glad Francis was, Dr. Francis, Pastor Francis, so glad he was there on the panel today because he says some of the things I want to say, but I can't say. But Dr. Francis and I, we've been fighting this issue for the last 6 years about prison reform, and him and I have been on panels together. I've been to his conference and all that, and sometimes we don't agree. But here's what we do. We do work to make sure that it works for our people. And we're unapologetic about the fact that it's hurting more black and poor people. What you're not discussing here is that that same way of not getting justice in those communities is another way of gentrification. Because as long as I'm not policing your neighborhood, mother, you're going to say, I got to move. When in reality, what I want to do is build a big Mercedes Dome. Oh, stop, Tony. I want to build a big Mercedes Domes because there's gold in the hood now. And if I can get you out and lock you up and put in laws where you can't come back and rent, or you're on probation, I can't allow you to get water for that condo or that loft that I now have in that neighborhood, you won't come back because you can't come back. There's a lot to this access, brothers and sisters, that we need to be talking about in Bible study in the church. My pastor, who's here today, Anthony Corbett, at Lundy Chapel, is doing some tremendous things throughout the state. My pastor at Fellowship Bible Church, he don't want youth to go to Bible study. What did he do? He said, open up the kitchen and teach them how to cook, and then give them a class how to survive a police stop. That's a game changer. And as Francis said, we got to be game changers. So glad you said that, Francis.
Fair enough. We're all glad to hear it. Rebecca, Troy, do y'all want to respond to that one? Okay. I was just curious. I didn't know if y'all had
Mainly because I don't deal with felony, so I don't know.
enough.
I'm doing everything I possibly can at the misdemeanor level and municipal court level, but it's just outside my bailiwick, so I don't want to.
Fair enough.
I think what he said was very good.
Another question from the group. When we speak of rehabilitation, what does that look like in the jury trial system? Why are people who go through it made to feel as if there is still a scarlet letter on their back after returning? This card had 3 questions, and the other one is not related, but it is such a good question. I want to share it with you. How can we give families more power when dealing with mental illness concerning a loved one? And I feel like those 2 questions, if you think about it, are related because so many people end up in trial. And so I'll let y'all respond.
Yeah, that one I will respond to. We especially, I mean, we see so many mentally ill defendants that come through these low-level courts. And, you know, what is so frustrating is that at the felony level, there are some pretty decent resources available to a mentally ill defendant. Whereas I'm stuck with community-based outpatient solutions that aren't necessarily always the solution. And I have regular people, I mean, regulars in my court who are there, and honestly, sometimes I think they do it so they can just get off the streets for a little bit and be taken care of. I mean, it is just devastating to me. And I will flat out tell you that you better believe that a mentally ill person is treated very differently in my court by my prosecutors than a person who is of normal faculties, because I feel fundamentally we do not take care of our mentally ill to the level we need to in this country, not just this state. And so, you know, I do everything I can to make sure that I know that if somebody's in custody, our nursing staff will go, especially if there's a hint of mental illness, they're meeting with them, they're trying to get them, you know, getting medications, getting services, that type of thing as quickly as possible, because they know that, I mean, I don't think I could make it any clearer to them that, no, I'm not looking for a conviction on a mentally ill person. I'm looking for treatment. And how do I help them stay on task and on path so they're not reoffending? I mean, that's probably one of my biggest things. And I don't know. I feel like we do not do enough. We actually need to have, I mean, as sad as it is, there truly are some people who cannot live and function out in the world. They honestly would be better served by being able to be in an institution where someone was truly looking out for them. And no, that's not wonderful. No, that's not ideal. But there truly are people who are at that level. And, you know, when we don't take care of them at that level, we're only setting them up to fail, because a schizophrenic, yeah, I've got one I've been dealing with for years. I mean, he calls me all hours of the night. I mean, God, he didn't know what he's saying. But, I mean, that's just a different ball game, and we have got to do better. And I wish I knew the answers.
Troy,
I want to very quickly address part A of that question, which is the issue regarding a jury trial and the right to a jury trial and having one. There is so much pressure placed on defendants to plead guilty. We'll give you 5 years of probation, but if you go to trial and lose, you'll have a 20-year sentence. That's crazy. That's not a right to a trial. That's a right to have a lesser punishment than a greater punishment. And that happens, we've got federal sentencing guidelines in the federal court system that allow this to happen on a widespread level in that court system. But we've got to do something, and I think the answer is legislation, in order to give people back their right to have a jury trial. You can't take a risk like that on a case like, these low-level courts, the kind of cases that Ferguson Court dealt with, like a DUI, is a very subjective type of charge. People may very well not be guilty of a DUI when they get pulled over, but you can't roll the dice if you're going to allow the prosecutor and the judge to send somebody into custody for 120 days, and they're going to lose their job, everything that they've got going for them in their personal lives, just because they want to tell the world that the cop got it wrong. That's a big problem in our justice system with the jury trial system that we're currently operating under.
Most definitely. We have 1 minute, Francis.
And I think I can do it in that time. There's over every seal on the state flag, 3 words: wisdom, justice, and moderation. And I think that's borrowed from Plato's Republic. But there's a fourth virtue of the city that is talked about there and of the individual, and that's the virtue of courage. That's not on the emblems and on the flag, but it is one of the four virtues that are listed there in Plato's Republic. And what is missing here when you talk about going to, you have to be courageous as a lawyer. And sure, you'll find yourself in the position I found myself yesterday in front of a judge who was bent out of shape because I wouldn't allow him to go outside of the statute. And I stood up for my client, and he says that I was making him look bad before an audience. You have to be courageous to try cases. You have to be courageous as pastors to show up for your people, for your congregation, and for people who don't have a congregation, who are part of your community. Courage is what's missing. And it's missing from the seal and the flag, and it's missing from the lives of the actors of these systems. So you're talking about mental health. It is courageous as Nathan Deal has been in terms of criminal justice reform. He should have had the courage to stand up and back his own policy that he supported when he was a member of Congress, to give block grants to the states to expand Medicaid, which would have helped alleviate some of the pressures of the mental strain on the mental health system that we have, giving more people access to services. But instead, he lacked the courage to do it. We can have no permanent friends, as well as I think of them as, in terms of criminal justice. These systems interlay and interlock with each other. No permanent friends or permanent enemies, just the permanent issue, which is the liberation of our people. And to that claim, what is missing, so many of us, and not myself excluded, I want to be more courageous as I move forward. Less politically expedient. Less concerned about maintaining social circles. But courageous, that's what's required in this moment.
My hope and our hope is that this panel has inspired you to go out and be courageous. Thank you to all of our panelists, and thank y'all.
I'm going to ask that James Rodatis start moving forward as our panel is leaving, but I do want to thank each of our panelists by name. Leslie Spornberger-Jones, who is our moderator, who is also a former municipal court judge. Rebecca Grist, who is a Solicitor General, Greist, who is a Solicitor General from Macon. Troy Hendrick, who is a partner at the law offices of Troy P. Hendrick. I also want to thank Francis Johnson, partner at the Johnson firm and former president of the Georgia NAACP, as well as Tony Loudon, the director of Faith and Justice Initiative. As they are moving toward their seats, I also want to give you all a couple of public service announcements. When I was coming in my desire to get us started on time, I failed to introduce myself, and so I would like to correct that. My name is Cassandra Kirk. I am the Chief Judge of the Fulton County Magistrate Court, and I actually just stood for election and won by 73% of the vote. What that should say to you, however, right? And so why I am absolutely overjoyed, and there were many pastors that allowed me to come, as Mr. Loudon said, and come and stand beside them. I had been fully vetted by those pastors. So here's what I want to say to you. When judges come, when elected officials come, sit down with them, take the time. Because I did have some pastors say to me, we don't do that at our church. One pastor on Easter Sunday allowed me to stand up and introduce myself, and I explained to the people at the church, I understand we're here to do church, but let me explain you. Church prepares you for the world. Part of the world includes the system in which I work. And so for those pastors that say this is not what we do, I say to you, stand up. And as Mr. Johnson said, have the courage to take full responsibility for your committee, because who sits on those benches, who is elected to those offices, it makes a difference. That's my introduction. So, let me talk to you. Before you leave, there are parking validation stickers at the registration desk, if you all would get those. If Mr. Rodatis, come on up. You know, Miss Tabitha Ponder wants us moving on time. I'm going to ask now if LaShawn Murphy will raise her hand here in the black and white. If everyone would turn and look at Miss Murphy. Do you have anything to set up, or are you just going to speak? All right. And so Miss Murphy is going to, she's going to actually turn in your surveys. There were some surveys that were given out. Do we need to talk about those surveys? Faith leaders have those surveys. If you all would please complete those. Thank you.
All right. y'all bear with me just a second while I get my mic set up.
Let's take a 5-minute break as we're getting set up.
Okay.
Let's go ahead and take it 5 minutes.
Yeah.
Okay, let's take a 5-minute break.
Clicker is not working. Like,
As a last resort, if it doesn't work, just go ahead and tell them to change it.
that's gonna not work if I need to advance the slides pretty quickly.
I can have Bill come up and talk to you.
The best thing would be to just put a laptop up here that could be connected to the screen. I don't know if that's possible, but I mean, without this, I'm just going to be speaking off my phone, off my notes. I mean, I don't know why it's not working, but it's not. I don't know if you guys need to change the batteries or what, but
Well, let's take care of this first.
all right.
I think what I'll do is you have an inside coat pocket on both sides.
Okay.
And I'll just put that in there. Does that sound good?
Yeah, that's fine.
Great. That's what I normally do.
Okay. Yeah, like,
There we go. I'll get Bill up here in just 1 second, okay?
okay. Yeah, that's not working.
Head up, please.
Oh,
Turn
sure.
towards me, please.
Gotcha.
Thank you.
Check, check.
I assume that you project when you speak. You sound like you do.
I do, yeah,
Good.
but I don't want it to be, I don't want to be running out of pipes when I'm up. All
be
right,
fine.
we're on.
Yeah, you'll be fine.
Excellent.
Let's see.
Check, check.
Go ahead.
Check, check.
Go ahead.
Check, check.
There you are.
All right, great.
So what I'll do, I'll adjust to the room, and everyone will be able to hear you. It'll be great. Hold on 1 second. Okay?
All right, gotcha. Can't work under these conditions. Yes, sir.
On the wall there, but I was standing behind about 3 people.
Okay.
To me, they could be law students. I don't know. And so, if they were standing there, they may have introduced themselves at the beginning of the meeting or whatever. I don't know.
Oh.
So I took an announcement. I just thought, is this you?
Yeah, that's me, James Herdatus.
So I'm just basically saying to you that I have to expect that this may reach the law students. If it
Oh.
reaches the law students,
That's
law
great.
Students, I have students that may have wanted to come and attend this council meeting.
Okay.
I just wanted to mention that.
That'd be great. But the Reform Council is sunset. So if it happens again, it'll take a different form. But I'll talk about that, and I'll make sure the law students are informed. How's the level? Or you'll get the level when we start.
I'm fine.
Sweet.
So, if you want to start, just make sure that when you come in, you get their attention. Right.
You got it. Okay. Just, yeah, it might need to be a little bit louder than it is now, but,
You're not on.
oh, okay. That's,
You're on,
but, okay. Awesome. Awesome.
I got you down. I'm turning you up for you.
All right. Perfect. I'll introduce myself. Yeah, whenever you guys are ready. Okay, fantastic. I'm ready. Let's do it. Could you light me at 5 minutes just so I save some time for questions and make sure I get to the
Absolutely.
Awesome.
If I could have you all come back together. I know it's hard to make people of faith stop speaking. If you all would come back together, we are ready to start our next presentation. Thank you all. And do you have a bio? Or they introduce you?
I can introduce myself.
All right.
Good to go.
James Rodatus.
All right, everyone. Thanks so much for coming. I'll wait till folks start sitting down. Do want to make sure I get to everything, but also don't want to keep anyone from lunch. All right, so thanks everyone for having me. I'm James Rodatus. I'm a staff attorney and policy analyst at the Administrative Office of the Courts, and I covered the Criminal Justice Reform Council meetings from our office, and I was also staff to the Misdemeanor Bail Reform Committee for the Judicial Council. So I'm going to be going through a lot of what the Criminal Justice Reform Council has done, some of the results that they've achieved, and finally talk about what all we have left to do, because there's still quite a bit. All right, so why do we have the Criminal Justice Reform Council in the first place? In 2011, previous 2 decades saw Georgia's inmate population more than double. Georgia had one of the highest proportions of adult residents under correctional control in the country. And spending on that population, $1 billion a year. And despite all that, there wasn't much of a public safety benefit. Recidivism rates remained the same. Crime rates didn't seem to be changing much depending on the correctional population. And the projection was that we would have 60,000 inmates in 2016 with additional cost of $264 million. So we're spending a lot of money, not getting much of a return on the investment. Now, 60% of the offenders sentenced to prison in 2010 were drug and property offenses. And 25% of those admissions were categorized as low risk, and they were people that had never been to prison before. Now, you combine this with a lack of correctional resources and a lack of available sentencing alternatives, you've got something that definitely needs addressing, and it's something where you have costs going out of control without much benefit. So, the interesting thing about the way this worked, the council was the initiative for Governor Nathan Deal, and it had 3 goals, which you can't see right now, so I'll just pull up my notes. All right. So the first was to address the state's prison population and contain correction costs and increase the efficiencies and effectiveness that result in better offender management. Then, next goal was to improve public safety by reinvesting that cost savings into strategies that reduce crime and recidivism. And we're back. And we're gone, but that's okay. Number 3, we also want to hold offenders accountable by strengthening community-based supervision, sanctions, and services. So what you had at the Criminal Justice Reform Council was chaired by Justice Michael Boggs, and it was also co-chaired by an attorney most recently, Carrie Miller from the Governor's Counsel's Office. But we also had stakeholders from the entire criminal justice system. We had judges from Georgia's various classes of court. We had sheriffs, prosecutors, and police. But we also had public defenders and defense attorneys in private practice. Not only that, we had court administrators and business leaders as well. And this council was taking an all aspects look at criminal justice reform, and they were looking at the problem holistically. Now, the council also heard from various groups like the Southern Center for Human Rights and the ACLU. And they also had research conducted by groups like the Council for State Governments and the Pew Charitable Trust. That's because a lot of the council's initiatives were data-driven. When you have data, you end up removing a lot of the partisanship and the ideology and the preconceived notions. When you've got data on what's working and what's not working, you can drill down and go after what actually works. Now, the way the council worked, they would meet leading up to the legislative session. They would draft a report with a series of recommendations that had already been vetted by police, by prosecutors, and various other stakeholders, by defense attorneys, by business leaders. And they would come up with solutions. So the equation that I like to use for criminal justice reform, you get groups like the Georgia Sheriff's Association or Prosecuting Attorneys Councils, plus groups like the ACLU and the Southern Center for Human Rights, plus, and this is important, solid data. That equals effective and politically achievable policy and legislative recommendations. The council's reports each year were then handed off to legislators who would draft a massive criminal justice reform package. And all of these bills went through the legislature with minimal opposition. Most of them passed unanimously with bipartisan support. So some of the major initiatives, I'm going to focus on a few. Some of them I'm going to go quickly on because I do want to make sure I save some time at the end for any questions and to make sure we talk about what's happening next. Accountability courts and other community-based options. Sentencing reforms, especially on non-violent felonies. Juvenile court reforms designed to get young people out of home placements in correctional facilities and into community-based programs. And re-entry initiatives to make sure when people got out of prison, they would have alternatives other than crime. And probation reforms, both misdemeanor and felony. And finally, the panel touched a lot on this, but I think it's very important, so I'm going to touch on it again. Changes to driver's license suspension laws. Seemingly inconsequential thing to a lot of people, but I'll talk about it further, how that can be one of the most devastating things that can happen to someone. And finally, this past year, the council touched on bail reform. Now, starting off talking about accountability courts. These are courts that are designed to get to the root cause of why someone's offending. We have mental health courts, DUI courts, drug courts, veteran courts, and family treatment courts. They're all designed to get to the root cause of why people keep reoffending, so we spend the resources on them early, we don't have to spend the resources on them later, and we divert these people from the correctional system. The Reform Council actually created a council of accountability court judges, and this council has mandated standards for accountability courts. There is a peer review process to make sure these courts are operating correctly, and these courts have state funding now. Essentially, these courts give judges options. For a lot of judges, if they had someone on a low-level drug or property offense, and as many of you may know, a lot of property offenses, the root underlying cause for that is a substance abuse problem. A lot of judges didn't have any other options other than prison. Now they do. They've got treatment options that can get to the root cause of why people keep reoffending. Now, this, I think, is really important. When the Reform Council started, there were 12 state-funded accountability courts throughout the state. There were some more locally funded and grant-funded accountability courts, but there were only 12 state-funded. Now there are 149. So a lot more judges have a lot more options other than prison. Now, moving on to nonviolent sentencing reforms. The Reform Council looked at our theft laws and our drug laws. Theft and burglary. The amounts have not been adjusted for inflation until the Reform Council looked at them since 1982. There was no Back to the Future movie, and I believe our most recent James Bond was Roger Moore. That's how long ago that was. Now, burglary, it's divided into 2 degrees, separating the very dangerous burglaries, dwelling house burglaries, from what is now second-degree burglary. That's burglary of any non-dwelling house, an unoccupied structure. And felony theft thresholds were increased dramatically, from $300 to $800 for shoplifting and $500 to $1,500 for most other property crimes. It makes sure that our theft laws are more proportionate, more just, and we're diverting a lot of people away from the felony system to the misdemeanor system. And there's now a graduated system of penalties for drug possession based on weight. All right, probation reforms. I'm not going to spend as much time on felony reforms because they're a bit complex, but they are important. But in kind of the spirit of the panel and the conference, I want to talk more about the misdemeanor reforms. Georgia had the highest, we may still have the highest, felony probation rate in the country, more than Texas, more than North Carolina. 2 big drivers of this. 1, probation was widely used in place of incarceration for a lot of sentences. And 2, state was imposing lengthy probation sentences, and that includes what's called a split sentence, where a person would have, say, 5 years in prison and an additional 5 to 10 years on probation. That costs a lot in terms of resources to supervise all those people. We also have a high number of misdemeanor probationers. In 2013, this is the best data I could find on this, we had 175,000 people on misdemeanor probation. 80% of these probationers were supervised by private companies. And that led to some rather alarming trends. So the first felony probation initiative I want to talk about briefly, it's the behavioral incentive date. A lot of these policies came out of research done by the Council of State Governments. And it turns out that if people are compliant in the first 2 to 3 years of their probation, they will likely be compliant for the next 10. Behavioral incentive date is designed for first-time felony offenders if they don't have any prior felony convictions, if they've been compliant with their probation at the date of the behavioral incentive date, the Department of Community Supervision issues an order requesting the judge terminate supervision. Similar process is there for probationers who are already on lengthy probation sentences for qualified nonviolent offenses. That's basically all of your drug and property offenses with the exception of drug trafficking and first-degree burglary. And it's a similar procedure except the department issues a petition rather than an order. The goal of all of these is to make sure we're getting nonviolent, low-risk offenders off of supervision when they don't need to be, and this enables the state to focus. Yes, sir?
Can you go back to the 2 screens back where it says not to be more than 3 years?
That's a behavioral incentive date. It's not to be more than 3 years from the date of sentence. So,
Well, they're violating that, I can tell you. They're violating that. Years ago, they were loading up probationers in state court with...
This would only apply to felonies, not misdemeanors in state court. I'm going to get to misdemeanor probation in just a moment, but that's okay. Probation law is not the easiest thing out there. It's only trumped, in my opinion, by suspended licenses, which can be a very complex and difficult area of the law to figure out.
I thought we were on private probation companies on this.
Yeah, I'm going to talk about that in a second. I want to make sure I reserve enough time for it. No, that's okay. And if you do notice that judges are violating this, because a big thing the panel touched on previously, the statutory reforms are not the end goal. It's step 1. There's a greater step that involves changing the culture around these offenses.
We don't have private probation companies supervising felons in Georgia.
No, it's all done by the state. All right, so moving on, good segue, to misdemeanor probation. All right, this is a quote from Justice Boggs. "The moral imperative is clear. The inequities and abuses that were pointed out in the audit and through anecdotal stories deserve immediate attention." I'll think about that for a second. Things had gotten so bad in our misdemeanor probation system that there wasn't just a legal imperative, there was a moral imperative for change. I could spend the entire next amount of time that I have left and all of your lunch hour going over these inequities. Just to list a few, a lot of people had probation fees still being collected long after all their other probation obligations were finished. If they had a fine or fee that they needed to pay, they might have paid all that off, then they'd have months left of probation fees that they need to pay for supervision that was non-existent. You'd also have fines and fees that were assessed without determining if the probationer had the ability to pay. And sometimes people were jailed because of that. And the law is, and it's been this way since 1983, again, most recent James Bond being Roger Moore, Bearden versus Georgia, you cannot jail someone for failing to pay unless that failure to pay is willful. It is unconstitutional. So some of the misdemeanor reforms, and folks, if you'd like more details on this, we have the Administrative Office of the Courts worked on creating probation bench cards for judges. We're trying to get this information out there so that judges are making the correct decisions and that they've got the information they need. There's now an affidavit requirement before probation officers seek an arrest warrant for failing to report. They have to make several steps before they can seek an arrest warrant for someone. There's also a requirement of a hearing for misdemeanor probationers before they can be arrested solely for failing to pay. Someone fails to pay, rather than an arrest warrant being issued, a show cause is issued, and a judge can look into why that person hasn't paid. It could be that they just don't feel like paying. It could also be because they may have lost their job, or they may have other necessary expenses, and if that failure to pay is not willful, the person cannot be jailed for it. Again, that's law since 1983, but that is now codified in statute as well. We've also got statutory guidelines for converting fines and fees to community service. And there's now statutory authority that's clear on instances where judges can waive fines and fees upon a finding of significant financial hardship, and a statutory definition for what that is. Now, reforms to the juvenile system, there's a lot here, and I've only got a limited amount of time, but the council found basically that a lot of money was spent on out-of-home placement with little benefit to public safety. 2/3 of the Department of Juvenile Justice's $300 million budget was spent on out-of-home facilities. Despite that expense, nearly half of the offenders in the juvenile justice system recidivate within 3 years. So again, lots of money being spent, lots of people being locked up, little to no benefit. You're starting to see a theme here, I think. So now that there's greater emphasis on community-based rehabilitative programs, and there is now regular audits of justice programs, practices, and facilities, so we can get down into the data to see what works, what's most effective, and what's most cost-effective. Reforming reentry, again, I could do an entire half hour just on this. One of the biggest initiatives was banning the box. This is why we had business leaders at the table. A lot of times, previous panel mentioned how a criminal conviction can be a scarlet letter on a job application. And to quote Governor Deal, if they can find employment, if they can find a place to live, I believe many of them will work hard to earn their place in society. A lot of people, when they get out of prison, even if they want to work and make a life for themselves, they have difficulties doing so because of a criminal conviction, hence the Ban the Box initiative. Also, it's tough to find a place to live with a criminal conviction. A lot of landlords and public housing have regulations against that, so there's initiatives and policies to help offenders find affordable housing. And again, driver's licensing, it's something a lot of people don't think about, but it's very important. DDS is now set up to get people inside prison an ID, or in some cases, a driver's license, so when they get out, they can start getting transportation and start getting to work. That's a woman in the front commented that that's going to be huge, and that's right. It's just a simple document that can change someone's life. And so let's get to driver's license reforms. Previous panel touched on this. Previously, before the council took a look at it, you could get your license suspended for things that had nothing to do with driving, drug offenses, truancy, underage alcohol possession. And all that was doing, it wasn't making the roads any safer, and it was preventing people from getting to work and turning themselves around. So the process of getting one's license reinstated, it's not easy. It's not inexpensive either. And most people who have a suspended license, they continue to drive. And I believe Troy mentioned this on the previous panel, they do it because they have to. If you've got to pay the rent, we all have to eat. If you have to take care of your children, you've got to drive to work. So we've eliminated many of the non-highway safety license suspensions. And the other thing to consider with this, suspended license charges, they take up a lot of time and resources on the part of prosecutors and courts. So again, we're trying to divert people who are not a risk to public safety and focus our resources on the more dangerous people that we're dealing with in lower level courts, such as DUIs, domestic violence. Again, we're seeing that theme. We've also got conditional licenses for accountability court participants. So if you're in a DUI court, a drug court, you can have a conditional driver's license so you can get to your court sessions and get to work. And there's also a pauper's affidavit now to where if someone needs to get their license reinstated, they can fill out this affidavit, and if they meet the poverty guidelines, that fee can be reduced by 50%. I'll be honest with you, it's still not exactly cheap, but it is something. And this is a big change. Again, this might not seem that consequential, but I believe this has saved a lot of people for getting their driver's license suspended. As the previous panel mentioned, in Georgia, you can do a year in jail for a simple moving violation. You can pay up to a $1,000 fine. And if you fail to appear for that charge, your license can be suspended. Now, if you fail to appear on the date listed on your traffic citation, rather than suspend your license, rather than issue a bench warrant, a court has to issue a 30-day notice, giving the driver time to resolve their case or come in, waive arraignment, and plea not guilty. A lot of times people forget their court dates, and it's not something that should result in a jail sentence or a license suspension, and this law does something about that. Now, moving on to bail reform. I was staff of the Judicial Council's ad hoc committee on this. We only took a look at misdemeanor bail reform. I'll go ahead and tell you up top, there's a lot more work to be done. We did as much as we could in the time that we had, but there's a lot more work to be done on this issue. All right, well, going from my notes. Now, this was in response to situations like Walker versus Calhoun. That's a case where a person was arrested on a local ordinance charge, spent, I believe, weeks in jail before he could get a hearing in front of a judge because he could not make a low-level bond. I believe it was like $200. Now, there wasn't a hearing to determine this person's public safety risk or his ability to pay. Essentially, what we're saying with a bail schedule is, if you're arrested on a charge and the bond for that charge is $200, we're saying if you have $200, you're safe and not a pretrial risk or flight risk, and you can be released. If you don't have $200, you are unsafe and therefore should stay in jail. That's not how bail should work. And I don't think I'm breaking any new ground by saying that. And the fact of the matter is, we looked at a lot of studies from groups like the Pretrial Justice Institute. It turns out that a stay in jail pretrial for as little as 3 days can have devastating consequences. It can lead to a loss of job. It can lead to a loss of a place to live. And not only that, I believe the recidivism rates, if you stay in jail pretrial for more than 3 days, can raise the recidivism rate on people by 30%. So again, and not only that, holding people in jail isn't inexpensive. So again, spending a lot of money on people that don't show a public safety risk and getting little benefit in return. So I think Judge Jones mentioned The data I have, it's about the same. 64% of all jail inmates are in jail awaiting trial. These are people who have not been convicted. So here's some of the initiatives that the Bail Reform Council was successful at passing. In statute now, there is a provision for unsecured bonds. This means if you are booked into jail, a judge can issue a bond in any amount, but the person doesn't have to put up that money right away. They would only owe their bond money if they missed a court date or violated a bond condition. We also required judges to hold an ability to pay hearing if someone is held in jail. That's one of the biggest issues with the use of bail schedules. We're not actually looking at whether or not someone has the ability to pay. I just heard on NPR this morning that Harvey Weinstein was given $1 million bond on, I believe the charge was rape and sexual assault in New York. He was able to make that within hours. Mr. Walker, in the Calhoun case, was not able to make $200 within weeks. And I don't think it's too hard to figure out who the greater public safety risk is. So, we've also, this is, again, a relatively minor thing. The AOC is working on developing model contracts for court reminder systems. I would not be able to make my doctor's appointments or my haircut appointments without a little text reminder coming to my phone and telling me that I had an appointment coming up. If my barber can send me a text reminder for a haircut, it's not too far of a reach for a court to be able to do the same for a traffic citation. And I think that's going to save a lot of people from bench warrants, from jail stays, from failure to appear fees, just from a simple and low-cost system. We've also clarified the law that bail may be set by any judge of a court of inquiry. And what that means is, in Calhoun, we have municipal court judges. Sometimes a municipal court judge may not be available. What this change in the law clarifies is that a magistrate judge who may be more readily available can set bond in a quick and efficient manner so people aren't held in jail waiting for a hearing. So let's look at some of the results. And by the way, when it comes to the results, I'm pointing out the positive results, but I'm in no way minimizing the fact that there's a lot left to be done. So between 2009 and 2017, the proportion of violent offenders and sex offenders in prison increased from 58 to 68%. And what that means is we're actually using our prisons for what they were originally designed to be used for housing people that are truly dangerous, who truly present a public safety risk. But during that time, our prison population went down to 52,962 from a peak of 54,000 in 2012. That's well below the 60,000 anticipated for 2018. Our annual commitments to prison are down from 21,000 in 2009 to 17,000 in 2017. I think this is really important. The number of African Americans committed to prison in 2017, 9,298, at its lowest level since 1987. So those are some big changes through concentrated reforms and result in data-driven reforms. We also saw a 14% drop in the secured population of juveniles in the state. And accountability court participation increased by 24%. That led to a cost savings of $75 million by diverting people from prison to treatment programs that are evidence-based, that are shown to work. So, as the chair of the Criminal Justice Reform Council said, by any reasonable measure, our efforts in correcting iniquities within our criminal justice system over the past several years have proven to be an enormous success. But I certainly don't think it's time for us to raise the mission accomplished banner yet. Despite all we've been able to accomplish, much more work needs to be done. So let's talk about what's next. Fine and fee reforms. I was going to start this conversation about recent legislation that was passed. Instead, anyone hear about the city of Doraville on the radio or in the news this morning? Okay, a couple of nods. Turns out the city of Doraville is getting 25% of its revenue through court-imposed fines and fees. Now, for those of you who don't practice especially in a municipal court or state court on a regular basis, when a prosecutor and a judge and a defense attorney agree on a fine of $200, that fine may seem just, it may seem proportionate to the crime, but then by the time all of the fines, fees, and add-ons are taken up in the clerk's office, that fine can sometimes double. So we need to take a longer and more concentrated look at the way these fines and fees are assessed. And that's not to say that some of these fines and fees don't go to worthy and worthwhile causes and groups and organizations, like the Brain and Spinal Injury Trust Fund and that sort of thing. But we need to make sure we're not funding these things off of people sometimes who don't even have the ability to pay. So there needs to be a harder look at that. And we need to make sure that cities aren't simply using their courts as a revenue generation system, that they're using their courts as an instrument of justice and to increase public safety. Criminal justice data exchange. Now, just going back to fines and fees for a second, that is something the legislature has said they are going to take a more concentrated look at. Criminal Justice Reform Council, it has sunset. We are now down to 3 choices of a possible governor in Georgia. All of them, as far as I know, have applauded the Criminal Justice Reform Council's efforts, but I'm not sure what Criminal Justice Reform Council, what criminal justice reform initiatives will look like under a new administration. But I do think that fines and fees is going to be something the legislature will look at regardless. Criminal justice data exchange, this is something that's already in place. And again, kind of like driver's licensing reforms, it doesn't seem that consequential that courts now will have a more centralized portal to look at offender data. But think about this. On my morning commute from Decatur to downtown Atlanta, I pass through the jurisdiction of Municipal Police of Decatur, unincorporated DeKalb County Police, and City of Atlanta Police. I can get 3 separate charges from 3 separate jurisdictions on my morning commute, and those 3 judges that handle my case won't know about them. Better data hopefully will lead to better and more proportionate sentences. It won't lead to people having multiple probation sentences out of multiple courts. Also, the panel talked about this previously. I want to talk about it some more because I think it is key. Misdemeanor citations and misdemeanor classifications. Misdemeanor classification, I think, is the key to unlocking a lot of bail reform initiatives and a lot of citation initiatives. I like to say about misdemeanors is that at the top level, multiple offender DUIs and domestic violence, a lot of people think, gosh, why isn't that a felony? At the bottom level, things like public intoxication, people think, gosh, why is that even illegal? You've got to classify your misdemeanors to make sure they have proportionate sentences and people are not giving disproportionate outcomes based on their financial ability or their ability to bond out of jail. I previously practiced in Virginia as well as Georgia. Virginia has traffic citations, which are non-jailable traffic offenses for most moving violations, and they have 4 classes of misdemeanors. The bottom 2 cannot, by law, carry jail time. But we've got a lot of misdemeanors in Georgia, and we've got to make sure we're classifying them correctly, but if you do that, that leads to a cultural shift, I think, on what misdemeanors you can issue a citation for versus which misdemeanors require an arrest, which misdemeanors you can allow an automatic own recognizance release versus which misdemeanors require a bail hearing. But classification, I think, is the key. And the good news is solicitors, prosecutors, police, and defense attorneys and the Southern Center for Human Rights are all on board. They're going to have maybe some slightly different ideas on how to do it, but everyone's on board that it needs to be done. Traffic violation reform. I won't spend too much time on this. The panel talked about it previously, but we need to look at a way to make sure that the law that all of us violate most often, the Motor Vehicle Code, doesn't lead to jail time unless it's for something like a DUI or reckless driving or something that is a serious public safety risk. Again, going back to the theme, focusing our resources on the public safety risk offenses and diverting people who are not public safety risk to less serious alternatives. I think we need continued reform in license suspension laws. The Reform Council did an excellent job looking at this already, but I think the reinstatement process needs to be faster and more efficient. Also, no one has taken a look at the relationship between license suspension and failure to pay child support. That might be something that future administrations would take a look at. But that's basically all of what I have as far as where we've been, the results we've achieved, and what's left to do. I'm sure I've left some things out. I've got a few minutes for questions, I think. Go ahead now. Oh, wow.
So I just wanted to know, with regard to fees and fines,
Mm-hmm.
is there any talk about those kinds of things being discharged in Chapter 7, or if there's just an inability to pay? So I'm hearing about the judges issuing hardship,
Mm-hmm.
waivers, whatever. So is there anything with regard to bankruptcy?
I'm not sure if there's anything directly related to bankruptcy law. I'd actually have to look at our misdemeanor probation bench card. We have samples of those if you'd like to pick them up. But significant financial hardship is defined in the code. If you've been recently incarcerated, if you're on disability, if I think there's an income guideline on there as well. That can be used as a determination for significant financial hardship. I don't know if recent bankruptcy is another one of those things, but there's only a few ways that a court can legally collect a judgment. They can do a tax refund intercept. They can file a FIFE, the solicitor's office can, to collect an enforceable judgment. I think the problem we may have is that there's some courts that aren't doing that. There's some courts that are sending their fines and fees to collection agencies directly without going through the correct process. But I think that's a good idea that if we could link up maybe bankruptcy filings with the significant financial hardship definition, that's something courts should take into account. That's certainly something worth exploring. So any other questions? I know we want to eat, but go ahead, sir. Yes?
Just the same question I had
Okay.
earlier. You said
Oh, remind me again?
about misdemeanor sentences and the length of supervision.
Okay. So with the misdemeanor probation reforms, there is a provision now that courts, if someone has satisfied all of their obligations, that courts can essentially order that termination is ended, especially if someone's on pay-only probation. You know, if you're on probation for something like a DUI, there is a public safety interest in making sure that someone is continually monitored. But a lot of our probation companies, they're just there to make sure you keep paying your fine and that sort of thing. And there's now provisions in law, and they're on our misdemeanor probation bench card, that require a court to terminate probation once someone's financial obligations are met.
Where the question
Yes, sir.
stems from
Mhm.
is years and years ago, back in the 80s
Mhm.
in Georgia, we used to have dramatically longer sentences for misdemeanors. Then
Mhm.
there was a move afoot to only supervise probationers for a couple of years.
Mhm.
And that's really the most supervision that occurs even on a felony for the first couple of years.
Mhm.
You know, reporting and so forth, and then they get through that kind of period of reporting in person or whatever they're doing. And in misdemeanors, it's similar.
Mhm.
Now, sometimes as a result of creative sentencing, for instance, a series of domestic violence-related felonies can
Mhm.
be reduced down because the defendant doesn't want felonies on his
Mhm.
record, so a series of terroristic threats, you know, some slaps, you know.
Okay, and then what that would be reduced to a lengthy misdemeanor sentence?
Well, some consecutive sentences.
So someone has multiple counts of family violence, they're sentenced consecutively to 4 years of misdemeanor.
Yes, sir.
Mhm.
And then for long periods? And that's my question.
That is an interesting question, because that kind of, it falls outside of the provisions of the behavioral incentive date, because that applies to felonies, but it may not apply to the.
Actually, it's misdemeanors that are
Right.
supervised by a private company.
And I think that may be an area of the law that needs to be looked at. I don't think that's a common situation, but if a defendant is in that situation, it's certainly pertinent to them, and that probably is something that should be looked at.
It's a private company supervision.
Okay.
That's why I've asked the question.
All right. Well, I think that's all the time I have. I think everybody's hungry, but thank you all so much for having me, and please pick up a copy of our bench card if you get the chance.
Please feel free to talk to them in our 45 minutes that we will have for lunch. If I could have the following people please stand: Donald Plummer, David Bonslar, Roosevelt Glover, Cornelius Ponder, Jeffrey Hill, Lorenzo Lewis, Daniel Simmons, Gloria Ricks, Gregory Thomas. I am so sorry, maybe Douglas Johnson. Is that correct? If you all would go ahead and head to lunch, you all are the people that have agreed to give interviews so that we can get a better understanding of this. So in acknowledgement of thanking you all get to eat first. So thank you. So our lunch break will be about 45 minutes. And if you all would go ahead and move to that area so that we can get started. Those people whose names I've called, if you all would go ahead and grab your lunches and then move to that area so that we can get that started. Everyone else, enjoy your lunch. We'll be back in 45 minutes. Thank you.